All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here for oral argument in case number CV17-0562, Gibson v. THEUT et al. As you probably know, these proceedings are being video and audio recorded, so we'd be grateful if each attorney, as he or she approaches the podium, give us your name and the name of the client that you are representing. Each side is allotted 20 minutes for argument. The appellant may reserve an amount of time to use in rebuttal, and the appellee may distribute that time as you see fit. But for both of you, the clock will just reflect the total amount of time remaining, whether that's in reserved time or reserved for one of your co-counsel. Please do keep in mind we've read the briefs, we have viewed the record, we have conferenced the case and discussed it, and with that, you may proceed with your argument.
Good morning, may it please the court. My name is David Abney. I'm representing Stephen Gibson Jr. I'm here today also with Matthew Riggs, my co-counsel. It's an honor and a privilege to speak with you today, and it's an honor and a privilege to represent Stephen Gibson Jr. He is not my favorite client. He did a horrendous thing. He killed his father and has been sentenced to a long term in prison for that. But still, he's my client. And it's an honor to represent anybody, quite frankly, and to do the best you can for that client. The problem here is that these two attorneys, the guardian ad litem and the appointed lawyer, did not take seriously their responsibility to represent this client, to do the best they could in a very tough case for a young man who had nobody else to depend on, a young man that they were specifically appointed to represent in this one particular case, and that they let down in just about every way you can imagine. When summary judgment motion time came around, they had not done any discovery. They didn't do any discovery to prepare for that. They didn't depose anybody. Their responses to the summary judgment motions were laughable. They were very short. No cases were cited, no substantive discussion, no substantive opposition, and naturally they lost all of them. At the damages hearing, they let the client down again. They didn't present any witnesses. They didn't do anything to try to mitigate the situation, and there was mitigation material available. He killed his father, but still, he was 15 years old when that happened. He was young, he was dumb, and he was under severe stress. He had been abused for years by his father. His father had abused his sister. His father has abused his mother. He had threatened all three of them with death. He had terrorized them for year after year, and he snapped. Now, you could do something with that as a defense lawyer in a wrongful death case. They didn't do anything. On the damages in a wrongful death case, they could have done something worthwhile. I mean, they didn't even understand what the measure of damages was for a wrongful death. It's not the value of the person's life; it's the value to you as a survivor. So, if for instance, and the grandparents, his grandparents, the decedent's parents, did not even allege that they had an economic damage loss. You know, that we were depending on our son for economic reasons, and we're going to get a certain amount of money, and we are not going to get it any longer because he's gone. They didn't do that. So all you had was the emotional damages, and these lawyers just rolled over and said, when they were asked, well, is $50 million enough? Oh, sure. That's fine. Why not? He's going to be in prison a long time. You know, that's fine. That's not the way you protect your client's interests. There were ways to address this, to fight this, and they didn't do it. Now, they say, well, we've got judicial immunity. The guardian ad litem at least has the beginning of a colorable argument with that, because he's a guardian ad litem. And we all know guardian ad litems perform an essential role in the judicial system. You know, they report, they investigate, they supervise, they do all kinds of good things that help the judicial system along. But in this case, this particular guardian ad litem was appointed specifically to represent the best interest of this young man in this particular lawsuit. And the guardian ad litem took an active role in that, to the extent he took any role at all. He participated as part of the two-man team that the commissioner had appointed to represent this young man in this very challenging case. But Attorney Kilfoy, has nothing to stand between himself and liability. He had the duty to represent this young man, specifically appointed to represent this young man in one specific private lawsuit brought against this private defendant by private litigants, and he didn't do anything. He doesn't get judicial immunity just because the court appoints him, any more than I would get judicial immunity if this court appointed me to do something like to represent somebody. I just don't get it. And neither of these men got any judicial immunity of any kind. That's the crux of my argument. And
could you then spend some time focusing on the role of the county and the state?
We're not really 100% sure what the role of the county and the state is. We alleged it as well as we could in the complaint and laid out the facts as well as we could. We know, of course, that the judge appointed these two men, and that's clear. But is there somebody else in charge of supervising, controlling, and making sure that they do what they're supposed to do other than the appointing commissioner? We don't know, and we weren't able to find out because we didn't get any discovery. This was cut off at the motion to dismiss stage.
And does that matter if the decision maker, the authoritative decision maker, who's the judge who makes the appointment, regardless of what materials he relies on or what county or state resources may have gone into compiling a list of attorneys, it's the judge who makes the appointment. And does it matter what materials he's furnished?
Yes and no. Or maybe I should say no and yes. There's no way we're going to hold this appointed commissioner liable. He's got total, absolute immunity for appointing these two gentlemen. The difficulty is we don't know what's happening behind the scenes. After the appointment is made, does the county and or the state have any sort of a role in supervising and making sure that these men are doing what they're supposed to do? We don't know. And if when we get back and we get some discovery going, we find out that there is something going on there, that there is active supervision outside of the judge, if there is active control or supervision going on, then the county and the state may be liable.
Well, if we take a look at, let's say, the probation officer cases where a plaintiff, for example, wants to hold a probation officer and therefore the state and or county liable for somebody else's tort. There's Acevedo from the Supreme Court that basically considers the question of probation officer liability and says they're judicially immune when they're essentially doing judicial tasks. And it just strikes me that if there are county or state actors who are compiling lists or vetting lawyers for judges to appoint from, it's still, that's in the aid of the judicial function.
It sounds a lot like a judicial task. I will certainly give you that, Your Honor. Absolutely.
So, I mean, I just can say that when I was on the Coconino County Superior Court years ago, if I appointed lawyers, they were from a list, and as far as I know, the way the list was compiled was when a lawyer had a bar card and he signed up to be on the list, and then I appointed him.
Well, there may be, for that, I doubt there'd be any way to impose liability. But there may be more going on here that we don't know about after you get, the initial appointment going on. What's happening as far as supervising and controlling and making sure that the county and or the state are getting what they paid for. But of course, here they didn't get what they paid for at all.
I guess I understood one of your allegations in the complaint to be that these two individuals were placed on some list, and that there was either no investigation as to whether they were qualified to carry out the task they were going to be appointed for or not, which is different to me than the second issue that you're just now talking about, which is monitoring their work after they've been appointed. At least in the criminal context in the Hicks case, it suggests that the government does not have an obligation to they're not liable for the conduct of that attorney once they've been appointed by the court?
Well, well, for the first part, I guess there's two things going on here. One is what we explored briefly with Judge Thompson about what about liability for negligent vetting, investigating, assembling the list. That's a really tough call. If it was really badly done, maybe there's some sort of liability. Maybe you stepped so far outside of what you're supposed to be doing, but we'd have a hard time proving that. The other thing is there might be some liability. There might be some system for controlling, supervising these lawyers once they're appointed outside of the commissioner's hands. There may be some mechanism there. We just don't know because we weren't able to find out. And for that, there could be liability. It just depends on exactly how the system is set up. If we get back down, I mean, if the county and the state depart us at this stage and they're no longer in the case, we might be able to find out some of the details of that from discovery based upon what we can get from the lawyers, what they know about who was supervising them and controlling them and guiding them.
Just hypothetically, if the judge has multiple lists of lawyers, there's one list of lawyers for probate matters. There's a list of lawyers for personal injury matters or wrongful death matters. The judge picks from the wrong list. That's on the judge. That's a matter of judicial immunity, right? I'm so close to conceding that. I'd like to say that I can't concede it, but yeah, you're probably right. Okay.
If you pick somebody off the wrong list, of course, if they shouldn't have been on any list, if they were that bad, and I don't know. I mean, these people were probably good at routine probate things, probably. And I can understand feeling overwhelmed. Remember the story about John Adams, who represented the British soldiers during the Boston Massacre trial? He was reviled by the colonists for doing that. And he said, I have a duty. As a lawyer, I have a duty to represent these men and to help them to the best of my ability. Well, these lawyers had that same kind of duty. And that same tradition, the common law tradition that goes back hundreds of years, that when you take on a client, you do the best you can. You don't just give up. And if you want to go back to Cicero and Quintilian and Thomas Aquinas, if you want to go in the church tradition, it goes back thousands of years in the Western tradition. And these men had no clue about that at all.
But beyond, I mean, they had a bar card, and they're basically asked to help your client with what was going to be a default hearing. I mean, once he was convicted, there wasn't going to be any real issue about liability, right?
No, there would be. Now, you have all kinds of interesting admissions that come in even by statute. You can't deny certain things. But you can still go to the jury and say, ladies and gentlemen of the jury, what we have here is a young man who snapped and who was not really in control of what he was doing.
Mitigation.
Yes, and not just mitigation and damages. I think you could actually make a substantive defense to the wrongful death. Now, he gave up in the criminal case, and they could come back in. The grandparents could come back into the wrongful death case. Well, he gave up, and he gave up in the criminal case. He pleaded guilty.
Then he's stopped from denying a lot of things.
Yes, but we are in a state in Arizona. Juries can nullify whatever they want in a civil case, almost everything. They can say, we don't care that technically he's responsible. We think, as a matter of our sense of community justice, we shouldn't hold this young man liable any more than he is already being held liable in the criminal system. Or if they say, okay, we'll grant you, it's wrongful death, we're not going to award any damages because he's suffered enough.
The criminal plea came a fair ways into the civil case.
It came in, yes.
Accurate. Can you remind me of that time frame? How far had the civil case progressed at the time of his?
When I say into it, I think it was a couple months. Okay. Okay. Let's say more or less simultaneously then. But it doesn't mean you don't have a case. You can still fight liability. It'd be an uphill battle. It'd be a hard battle. It would take a gutsy lawyer to take on this case. It takes a gutsy lawyer to take on the appeal, quite frankly. But I'm doing the best I can, and they should have done the best they could. You really have something to work with here. It's not a slam dunk winner. As a tort lawyer, you'd love to take cases that are slam dunk winners, and this is not. But it's still a case where you could fight liability you'd probably get creamed, but you could fight it. But you could certainly fight on damages and have a chance, at least a chance, to make his position better than it turned out to be. And it turned out to be
I
a
guess
catastrophe.
just part of what occurs to me is that as the appointing judge, I would think that a lawyer with a bar card would know that even with liability established, you can go in and challenge the damages request.
One would hope. And I give the commissioner the highest possible marks. I think he understood that this was a bad situation. I think that's why he put 2 lawyers on it. And, of course, I haven't talked to the commissioner, but I would guess the commissioner was rather disappointed in what happened, but it happened. If I may reserve my remaining time, the time has flown. Okay, thank you.
Good morning, Your Honors. My name is Sean Moore, and I represent the THEUT defendants and Maricopa County in this case. I plan upon taking about 5 to 6 minutes and then reserving the remainder of my time for the co-defendants. After me will be Mr. Healy representing the Kilfoy's position, and then Ms. Starkey representing the state will be batting cleanup. All right, the first thing I want to address are the arguments considering the THEUT defendants, because I think that it's pretty straightforward, and the real issue here is immunity. Plaintiffs are going to need to change the law in order for any liability to attach to the THEUT defendants in this case. The Widoff case is 100% on point. It says guardians ad litem are entitled to absolute immunity. It's clear from both the complaint and the record that the THEUT defendants were appointed as guardians ad litem in this case, not as attorneys. And essentially, plaintiffs' briefs spend most of their time trying to get around this dispositive reality.
Is it your position that Mr. THEUT was acting on behalf of the court, not acting on behalf of the client to whom he was appointed to serve as GAL? That's what the Widoff case is about, is that the GAL who is appointed to serve on behalf of the court and thus is performing a judicial function should be entitled to judicial immunity. Are you saying that a GAL appointed in these circumstances who is directly appointed to serve on the client behalf is also serving the court?
Yes. Well, I believe that he is serving both the client and the court in this situation, Your Honor. He's serving the court in the sense that it's the court's responsibility to take care of indigent individuals, to take care of minors who might not be able to represent or obtain legal representation for themselves. The court has
So would it then be your position that public defenders should be entitled to full judicial immunity for their conduct? There's no malpractice against a public defender or any type of liability whatsoever for public defender? You would say a public defender is serving a judicial function?
Not necessarily, Your Honor. And there,
the dividing line.
The dividing line here is the practical concerns that go along with appointing a guardian ad litem versus appointing a public defender. If you look at the Widoff case explains there are all of these practical concerns that say why guardians ad litem need this judicial immunity. Otherwise, they won't be able to make decisions properly. They won't be able to represent their clients properly. They frankly won't be able to find people to serve in this role because it's a role that does not pay a lot. And if you
which of those considerations does not apply to a public defender?
The difference is you're making, as opposed to just representing someone in a lawsuit where they can make decisions for themselves, like the defendant in a criminal case can decide, I'm going to plead guilty, I'm going to plead not guilty. The minor in this case has no such choice, right? The guardian ad litem is stepping into the shoes of the minor and making decisions on their behalf. And essentially, if anything goes wrong at all in that situation, the minor's going to say, I would have chosen to do something differently, and now I'm going to sue the guardian ad litem. And that's the real difference here, is the fact that the guardian ad litem has to step into the shoes of someone else, make decisions as if they were that person, and then if they don't have judicial immunity, they have to suffer the consequences on the back end. And if they were potentially open to those consequences, then they would have to make all of those decisions out of fear. They would have to make decisions in such a way that they would minimize potential liability to themselves down the road, and potentially put their clients in a worse situation than they would be otherwise.
The guardian ad litem in Widoff represented a non-party, isn't that accurate?
I believe so, Your Honor, yeah. I mean, the thing is, the Widoff case does not distinguish guardians ad litem in this situation or guardians ad litem in that situation. It just says...
Situation wasn't at issue there, so
Correct.
It's not terribly surprising. But
Well, correct. It was not an issue there. But the bottom line is the Widoff case does not have any reservations as to when judicial immunity applies to guardians ad litem. And frankly, the fact that the judicial immunity that applies to guardians ad litem does not line up 100% snugly with the traditional conception of judicial immunity. Like, you are working on behalf of the court to help make judicial type decisions. And the reason is because the Widoff case extended that judicial immunity to guardians ad litem in this special situation because they realize, as a matter of practical concerns, guardians ad litem need to have this kind of immunity to do to do their job well, and two, so the government can even find people to fill this role. And it's really those practical concerns that drive the judicial immunity here rather than the traditional conception of what is judicial immunity. All right. So, getting into the couple arguments that they raise very briefly, they assert that THEUT was operating as a lawyer and not as a guardian. That's not supported by the complaint or the record. Their briefs spend a ton of time talking about how THEUT didn't do all of these things that an attorney normally would do, but they don't spend any time talking about what THEUT did do as an attorney, and that's frankly because he did nothing as an attorney. He wasn't an attorney here, he was a guardian ad litem. They talk about how he was not fulfilling a judicial role. I believe I talked about that in your questioning. Protecting children is a central purpose of the court, and he's a necessary aspect of fulfilling that purpose. They talk about how he did not follow the order. I believe this is addressed more than adequately in our briefs. Frankly, if a plaintiff was allowed to allege that and then get around the immunity would be completely meaningless. And then before I run out of time here, I just want to talk very briefly about the immunity of the county. I believe the panel hit on this very aptly in the opening remarks, so I won't spend too much time on this. The only thing that I want to talk about is when the plaintiff's counsel talked about what they don't know and what they could find out in discovery that might give rise to fault in this case. And frankly, that doesn't matter here because they don't allege anything in the complaint upon which liability could attach to the county. As Judge Thompson talked about, putting names on a list like this is necessary to fulfill the judicial role of appointing these people, appointing counsel, appointing guardians ad litem to represent these people. And there is certainly immunity for the judge when they make those appointments, and there's certainly immunity for the county when they enable the judge to make those appointments. And unless the court has any further questions for me, I would reserve the remainder of my time for...
Is it incumbent on your client and others on these lists when they're appointed to represent someone in a particular type of case? Is it incumbent on them to say, I'm not really qualified to represent this individual in this particular type of case?
Like, is it incumbent upon the appointed counsel to say that if they're not qualified? I believe that if the individual believes that they are not qualified to do it, then it would certainly behoove them to mention that to the court. But if they legitimately believe that they are qualified to do that, even if they may not be, I mean, you know, if you have your bar card, the state assumes that you can perform all functions of a lawyer, even though we know it's more complex than that. So I would say that it would probably behoove them to do that. I don't think that there's any legal requirement to do that one way or another. Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, my name is Sean Healy, and I am counsel for Mr. Kilfoy and his law firm. Your Honors, Mr. Kilfoy, like Mr. THEUT, the guardian ad litem, is entitled to immunity. He's entitled to absolute immunity. In addition, the claimant lacks standing to bring this claim. My client's position is that he was responding to, answering, and acting at the directive of the GAL, and is the GAL that would properly have standing. And finally, Your Honor, as stated in our papers, the claimant lacks, or the appellant lacks, causation here because he in fact murdered his father. And as Your Honor, Judge Thompson pointed out earlier, wasn't this essentially a default hearing? And I think you're referring to 13807, which doesn't allow you to deny the essential elements of a claim when you committed a crime, and if those essential elements are part of a civil claim. And then I think one of Your Honors might have touched on another issue, and that is 122506, which states that if you're acting in concert, you're jointly and severally liable. That's an exception to the comparative fault doctrine in our state. And I was just trying to touch on a couple of questions that the court raised. First, Your Honor, on immunity. It's Mr. Kilfoy's position that he is immune through the guardian ad litem, and two, because he was performing tasks that were integral to the judicial process, much like a psychologist, as noted in the Leavitt case, much like a guardian ad litem, as noted in Widoff, much like the attorney noted in the Karuba versus Moskowitz case, which is in the papers, much like the court appointee in the Burke case, where the court appointed someone from the Office of Conciliation Services to make recommendations regarding custody. And in that case, the court actually touched on, I think, Judge Winthrop's question, and that was...
In those cases, was the appointed individual representing a party to the case, or were they merely providing, for example, in Widoff, the GAL was appointed for a non-party, and I believe at least one of those, the expert, was appointed by the court to provide information to the court. But was the, I guess this is two-part. In any of those cases, is there an example of an appointed individual that owed duties to a party specifically? And is it your position that Attorney Kilfoy owed no duties whatsoever to Gibson? His only duties were owed to the GAL?
It is our position that his duties were to the GAL because the GAL stands in the shoes. The real party in interest is the minor, incapacitated minor, but his duties are to the person giving him direction. And that would be the GAL. So he does have a duty. He can't disregard the directives of the GAL. Otherwise, he's essentially disregarding the directives of his client, who's duty-bound to act in the best interest of the child. So if he were to disregard those directives of who legally is supposed to give him direction, he would obviously be not fulfilling his duties. And the second question, Your Honor, I believe in the Leavitt case, the parents sought the psychologist's assistance in connection with the resolution of their child custody dispute, and the divorce court adopted the psychologist's custody recommendations, and then one of the parents brought suit against the psychologist for, among other claims, intentional infliction of emotional distress, common law fraud, and negligent misrepresentation. And in that case, the court looked at the nature of the function performed, not the identity of the actor, and not how the psychologist was first chosen, but whether the activity was an integral part of the judicial process, which we have here. And that judicial process is simply the court's obligation under statutes 14 et sec to look out for the best interests of the minor. And so that case is very analogous to this case. Also, the Karuba case, Your Honor, that case, and admittedly it's a Connecticut Supreme Court case, but it contains very, very good reasoning. That case involved a prior marital dissolution action between a plaintiff and his former wife, the defendant. The defendant served as a court-appointed counsel for the minor children who was acting, and there was also a GAL involved. The plaintiff was not pleased with that counsel's actions on behalf of the minor children and commenced an action. The court didn't allow that action. It ruled that the lawyer was entitled to absolute immunity as a court-appointed lawyer. Very analogous to this case. For a minor acting through, and I'm quoting the case, through a guardian ad litem, he had to be more objective than a privately retained attorney. They've made the argument several times that my client was more analogous to a privately retained attorney, and we strongly disagree with that. The court noted in that case that the attorney was serving a dual role. One was as an advocate, but the other one was as a surrogate to the court, an extension of the court, and that was to act in the minor's best interests. So
I'd like to direct you back to your position about the duties. It seems to me what you're suggesting is that so the minor has a GAL because of a legal infirmity, because of the minor age. And that what we should do today is immunize your client from malpractice claims, which I don't see how that goes to protect the child's interests, which is the whole goal of these appointments. It serves instead rather to prejudice the child's interests by making it apparently okay to commit malpractice as long as your client is a minor and there's a GAL who is likewise failing to act appropriately.
Your Honor, for the purposes of this case, we have to assume the allegations in the complaint are true. However, I would, and I'll do deference, draw a distinction between second-guessing the actions of the GAL and Mr. Kilfoy, which is a different analysis. We have to assume that's true because it's in the complaint, versus their function, and their function is a judicial function. So if you look at the Burke case, for example, the Burke case actually states that the person that the court referred the case to determine who was the best parent for custody may have made a mistake, may have engaged in malice, may have had a discriminatory purpose, may have made an error, and in fact the court rejected their recommendation, I believe, of that person. That doesn't factor into this analysis. It's a functional analysis, and that's what role were they fulfilling. Unless your honors have any other questions, I will wrap up. We would, on behalf of Mr. Kilfoy, I would ask that this court uphold the trial court's ruling that he is immune from these claims and sustain that ruling. Thank you.
Good morning, Your Honors. May it please the Court, my name is Cynthia Starkey. I'm an Assistant Attorney General here on behalf of Appalachia, State of Arizona. The state only can act through an employee or an agent. And you heard opposing counsel say that the commissioner definitely was entitled to judicial immunity in this case, and that's why they didn't name the commissioner as a defendant in this case. Well, the state was acting through the commissioner, and if the commissioner has absolute judicial immunity, as opposing counsel has admitted that he has, then the state also has judicial immunity. Under ARS 12-820.01, that statute says, a public entity, the state, shall not be liable for acts and omissions of its employees constituting either of the following: the exercise of a judicial or legislative function. So here the judge has judicial immunity, the state has judicial immunity. That should be the end of the inquiry as far as the state goes. Mr. Gibson left the commissioner out of the complaint. It makes his claim seem a little bit more viable against the state. But if you put the commissioner back into the equation, as we really need to, because the state can't act by itself, it has to act through its employees. Here it acted through the commissioner or agents. Mr. Gibson claims that THEUT and Kilfoy, the attorneys that the commissioner appointed, are agents of the state, but that just simply, isn't true. Under the restatement second of agency, agents have to act on behalf of the principal. If the principal here is the state, then Kilfoy and THEUT are supposed to be acting on behalf of the state or the commissioner. And in fact, with respect to Kilfoy and THEUT, their allegiance and their interests and their actions are supposed to be on behalf of Mr. Gibson. Also, in order to have agency, the agent has to be subject to the principal's control. Here, once there's an appointment made in State v. Hicks, State v. Hicks says the state gets out of the way, the commissioner gets out of the way. There's no more control over that agent. And so there can't be an agency relationship. Under restatement third of agency, section 1.01, they also say that the principal has to have the right to terminate the agency relationship by revoking the agent's authority. And there's absolutely no doubt in this circumstance that the commissioner had no right to revoke the agency of Kilfoy and or to revoke the representation of the attorneys Kilfoy and THEUT and their representation of Mr. Gibson. That was only Mr. Gibson's right at that point, or perhaps it was the GL's right to revoke Mr. Kilfoy and make him not counsel for Mr. Gibson.
Mr. Gibson's counsel seemed to suggest that there's at least a fact question on these points as to what other involvement the state, or I guess possibly the county, may have had either in compiling the list of attorneys and vetting them, or subjecting them to subsequent supervision, or potentially firing if they were not doing the job. Is that a fact question? And if not, why not?
If it is a fact question, it really doesn't have anything to do with the issue of agency, Your Honor, because as a matter of law, regardless of what they plead in their complaint, as a matter of law, THEUT and Kilfoy aren't agents under, the points that I just made.
But I think that in the interest of time, because you're running out of it, there's another component to the complaint, which is not vicarious liability of the government agencies, but direct liability for some unnamed state or county actors who may have compiled the database from which lawyers would be selected. And so, I think that still raises questions of immunity, but they're different from vicarious liability, which seems to be more directly addressed by the Hicks case.
And I would say, Your Honor, that I can't speak for the county, but the allegations in the complaint say that the county is the one that had the contract with the attorneys, the county is the one who pre-selected and pre-qualified the attorneys, and the county is the one that paid the attorneys. So the state is not involved. If there are fact issues...
But the complaint does not allege this kind of direct liability?
It alleges direct liability, but it does it in just as a legal conclusion, and the factual allegations don't support that legal conclusion. I'm out of time. Thank you, Your Honors.
Certainly an interesting appeal. Part of the problem is we're talking about judicial function and sort of in the ether, and I think the term judicial function as really should be used in this particular kind of case is something that is a judge-related kind of function. If I'm appearing in court today, and in a sense I'm performing a judicial function, but I'm not a judge and I'm not appointed by a judge to do this. I'm doing my lawyer job is what I'm doing within the context of the judicial environment.
Perhaps the difference is that we didn't cause you to appear here, other than we didn't cause you to take the case.
No, Your Honor, you tolerate me being here, but you did not cause me being here. And I appreciate your tolerance very much. But judicial function really is judge-related or directly related to what the judge is up to. That sort of thing, I think, is a judicial function that's really when that term is being used here. If I may just make a brief comment, a slight detour, but State versus Hicks keeps coming up, and it was the duty to provide a indigent criminal defendant with competent legal counsel was discharged when the state appointed competent attorney. And here, the distinction between State versus Hicks and today is we say they appointed incompetent attorneys to handle this.
I think Hicks pretty expressly did not address this question.
Right. And I think this case...
That claim in Hicks had apparently been dismissed.
Right.
So they didn't address it.
And I think what we have here is an outlier. I haven't run across a case like this, really. I mean, you don't expect to run across a case like this. We all make mistakes as lawyers, and occasionally, with the exclusion of the three members of the panel, judges make mistakes. It's just part of working in a system where there's so many decisions to make and so many things to do. You're going to botch something sooner or later, and if you practice long enough, you're going to mess up a whole bunch of things. But when you have a client, though, you keep trying, you keep pushing, you do the best you can for that client, and going in, accepting the appointment as a lawyer, as a guardian ad litem to represent a client in a particular case. And as a lawyer picked out to represent a client in a particular case, you have an awesome responsibility to try the best you can, and these folks just did not do it. The notion that the minor is not the child is distressing. By the time everything went to went to blazes on this case. The minor was almost an adult. They were about 17 and a half or so when everything fell apart in this case. At the very least, you consult with the client is old enough to talk with and keep the client informed, which they didn't do. And always try the best you can for the client. On liability, uphill, terrible uphill fight. But certainly on damages, a challenging and interesting fight, and something that you probably could have won if they had just tried, and they didn't. Now, what happens in the end if we get back to court and the case goes forward? I don't know what's going to happen. I don't know. A jury may say, "Oh, pox on him. He's a bad person, and he's got everything he had coming to him." Or they may say, lawyers. They may say, "We understand. Lawyers have a job here, and if we hired a lawyer, we'd want the lawyer to do the best they could for us." So, looking into the future, this sort of idea that you sort of that Attorney Kilfoy was supposed to follow the lead and directions, I suppose, of the guardian ad litem is an interesting thing, but it's a very, very troubling thing. Number one, your primary duty is to the client, and number two, to get biblical as opposed to historical, you cannot serve two masters at the same time. You simply can't do it. You've got to say to yourself, "This is my client," and it may be unpopular. You may not have to be Atticus Finch and defend your client at the jailhouse door, but you certainly have to do the best you can, and these folks did not do it. I could go on forever and ever, and I'm afraid I'm going to get pathetic if I keep at it. I do appreciate very much and the time that you've given me. If there's any other questions, I'd be happy to answer. If not, my thanks.
Thank you all for your arguments. We'll take the matter under advisement, and the court will stand in recess. Actually, the court will be adjourned.